Hello friends, my name is Dr. Jigisha Singh, and in this video I'm going to explain you the concept of acceptance and the concept of communication of offer, communication of acceptance and communication of revocation. By revocation I mean revocation of offer and revocation of acceptance. As far as the definition of acceptance is concerned, it is provided under Section 2B of the Indian Contract Act, which states that when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Now, if we realize that as far as the definition of acceptance is concerned and the definition of offer is concerned, both use the word signify, which means both the offer and the acceptance must be communicated. So it is essential for us to know what communication is all about. So before I proceed with explaining the concept of acceptance, we would be discussing about the concept of communication. Now, communication, what are the methods of communication that are possible? There are two methods of communication that are possible. One is a direct method and the other is the indirect method. Section 3 deals with direct communication and Section 4, 5 and 6 deals with indirect communication. We will now look into the distinction between direct communication and indirect communication. Well, as far as the direct communication is concerned, ordinarily the parties are in physical presence of each other. However, in case of indirect communication, parties are invariably, with no exception, are not physically present with each other and they are physically absent from each other. In case of direct communication, the parties are communicating directly to each other and there is no third agency involved. In case of indirect communication, the parties' communication is through third person or agency. In case of direct communication, there is no time gap between sending of communication and receiving of communication. Communication is instantaneous without any time gap, as in the telephonic communication. Again, in case of indirect communication, there is time gap always. In case of direct communication, acceptance when communicated cannot be revoked. In case of indirect communication, acceptance once communicated can always be revoked. We must understand that a binding contract results as soon as the place, when and where communication of acceptance is complete. This point is necessary for the purpose of jurisdiction. For example, a party is from Bombay, a party is from Bombay and B, a party is from Chandigarh. In case of breach of contract, the question arises where will be the suit of breach be filed. Now the answer is where the contract comes into existence. The contract comes into existence where the communication is complete. So for that necessity, we have to understand the concept of communication when it is complete for the acceptance, offer or revocation. Now in case of direct communication, there are three possibilities. There is a direct communication of offer, there is a direct communication of acceptance, and there is a direct communication of revocation. As far as the direct communication of offer is concerned, the communication by the offerer to the acceptor is complete by the offerer when it comes to the actual knowledge of the person for whom it is made, that is the acceptor. In case of acceptance, when the acceptance is made by the acceptor to the offerer, communication is complete by the acceptor when it comes to the actual knowledge of the offerer. In case of revocation of offer, its communication is complete when it comes to the actual knowledge of the acceptor. However, it has to be made, communicated before the acceptance of the offer. Acceptance, the communication is complete when it comes to the actual knowledge of the offerer, and in case direct method, the acceptance once communicated cannot be revoked. Now we move on to indirect communication. There are again three possibilities. One is the indirect communication of offer, the indirect communication of acceptance, and the indirect communication of revocation. Now, as far as offer is concerned, the rule is the same as in the direct communication, which says that the communication is of the offer is complete when it comes to the actual knowledge of the acceptor. So there is no exception to that. It is a universal rule of law. As far as communication of acceptance is concerned, there are two possibilities which says as against the offerer or as against the acceptor. As against the offerer, it is complete when it is put in the course of transmission and it is out of the control of the acceptor. As against the offerer, it is as against the acceptor, it is complete when it comes to the actual knowledge of the offerer. Now, we should understand that in India, a binding contract for the acceptor results at the place and time when the acceptance is put in the course of transmission for the offerer. Now, it is binding on both the parties from the day acceptance is put in the course of transmission. However, it is only for the purpose of revocation a liberty is given to the acceptor to revoke the acceptance before the acceptance reaches the offerer. For example, now, in case the acceptor does not revoke his acceptance, then it would be taken that the consent is binding from the day it is put in the course of transmission. For example, letter is put in the course of transmission, acceptance letter, on 1st April 2026 and reaches offerer on 10th April 2026. Acceptor can revoke before 10th April 2026. If he does not, then the contract is binding from 1st April 2026. Again, if the letter of acceptance is put in the course of transmission on 1st April 2026 and reaches on 5th April 2026, then the revocation must reach the offerer before 5th April 2026. Otherwise, it is the acceptance that would prevail. If the letter is lost in the course of transmission, then we would assume the time period which is reasonably taken for the letter to reach the offerer, that would be considered. Now we move on to the concept of revocation, when the offerer can be revoked by the offerer. Offer can be revoked at any time before communication of acceptance is complete for the offerer. Again, in case the letter of acceptance and revocation reaches the together, in UK the law is whichever letter is opened first. In India, it is always revocation that will prevail. Now, as far as revocation of acceptance is concerned, acceptance can be revoked before or at the time communication of acceptance is complete as against the acceptor, but not afterwards. Now, there is another example. For example, A sends the letter of acceptance which is posted on 1st April 2026 and the notice of revocation reaches the offerer before acceptance. In that case, revocation is binding. Revocation is received after the acceptance received by the offerer. In that case, acceptance is binding and it leads to binding relationship between the offerer and the acceptor. Now, if the revocation is received before the acceptance, revocation will prevail. If the revocation is received after acceptance, then the acceptance will prevail. Revocation of offer must reach the acceptor before the communication of acceptance is complete for the offerer. With this, I conclude the concept of communication and I would be discussing about acceptance in the next lecture. Thank you.